right. So why are you going 100 miles per hour?
To be honest with you, Your Honor, that day I was going to school.
Don't be a leaf blowing around in the wind. You understand? All right, you can lower your hand. How old are you?
21.
You're 21. You want to go to prison? Do you want to be over in the box with those gentlemen over there? All right. How long have you been in custody in the other county?
About a week, ma'am.
All right.
I mean, I didn't know that I had consequences if I didn't do it. I thought that it just stayed on my record.
If you're gonna go off camera, you have to come on camera. Otherwise, I'm not gonna allow you to
Okay,
be
what do you want me to
interviewed.
do? Okay, I'll go get the drug and alcohol evaluation. I'm done with this. I'm done.
Do you understand what he's
It's
alleged?
amazing the way you speak. If you have to be precise.
Job to tell you the details, all right?
What do you mean it's not? You are
My job is to tell you the charge, all right? And where it's my job is to tell you where it's alleged that this has occurred.
So you are judging me without knowing the
No,
details?
I'm telling.
Reviewing State's Exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, sir.
Anything you wish to say on behalf of your client?
I would ask the court to follow the plea bargain. Mr. Ichortea has no criminal record. He's what, 20 years old, Your Honor. This was a big mistake. He understands that, and he'll do well on probation, I'm sure.
All right. So why are you going 100 miles per hour?
To be honest with you, Your Honor, that day I was going to school.
All right. So here's the thing, and your attorney will tell you this. When people start a sentence with, to be honest with you, usually what's coming after that is not honest. And then when people say, in all honesty, what's coming is not honesty. Whenever you hear people talking and they say, well, with all due respect, what's about to come is without respect. So you're speeding, going 100 miles per hour. Why?
I was going to school.
Yeah, but why are you going 100 miles per hour? Other people go to school. They're not going 100 miles per hour. I'm sorry, what?
I was running late, Your Honor.
So you're running late. And what school were you going to?
I was going to Pathways Home Education
And whose car were you in?
in my vehicle.
All right. Do you have insurance on that vehicle in your name?
Yes.
And were you paying for that vehicle and paying for the insurance?
Not the insurance, Your Honor.
Who was paying for the insurance?
Be my mother.
And so how long were you in doing home education with Pathways? And where were you doing education before Pathways?
It was Stevens High School.
All right. So why were you at Pathways home as opposed to Stevens?
I had dropped out at Stevens High School during the pandemic because they weren't allowing me present in my classes anymore.
Mm-hmm.
And I wanted to go back to school. So we had found an educational program for students that wanted to work from home, or if they wanted to, could go to the school physically, if they felt comfortable with it.
Mm-hmm.
And I was just running like that day. And I'm trying to go back to school now, really.
So have you graduated?
No.
So
when
how
I
do you-
went to jail, that kind of made everything fall apart.
And then I bet when you went to jail, that sort of woke you up too.
Yes, ma'am.
So how far did you go in school?
How far? About junior year.
So you're in your junior year, you're 20. School is different from when I went.
At that time,
It was rare that 18-year-olds were still in high school. They had already graduated. So I'm trying to figure out why
I
at
got held back in
20.
first grade.
I'm sorry?
I got held back in first grade,
Okay.
but I was 19 at the time, so I was still eligible for a high school diploma. So that's why I was going through that educational program to get my diploma.
All right. How long have you been out of custody?
State, I believe. To be honest with you, I don't remember.
You don't remember?
No.
All right. Either you're just trying to put that behind you or it didn't make enough of an impact. So have you been out of custody for more than a month? More than 3 months? More than 6 months? All right. So you haven't been in school since you've been out of custody. So what have you been doing?
I've been working, been hopping job from job.
Working, doing what?
I was working industrial, and then for a little bit, I was also working as a cook.
All right. When you say working industrial, what do you mean by that?
I mean, I made automotive vehicles. I worked for Toyota for a little bit.
Okay. And why did you stop working at Toyota?
I stopped working at Toyota because I couldn't do the hours. It was 2 weeks on day, 2 weeks on night, and trying to transition through that was really hard for me.
So you quit. And when you quit working at Toyota, did you give them a 2 weeks notice?
Yes, I did.
All right. And when you quit, did you already have another job lined up?
I was searching.
And is the reason why you didn't have another job lined up because you knew you could live with your mom?
Well, that, yes, and because I wanted to look for another opportunity somewhere.
Well, here's the thing. If you're living by yourself, or either if you're living and the household is dependent on your income, you can't just say, this job, I don't like their hours, so I'm going to quit. Here's my 2 week notice and I don't have anything fall back on. Because for example, if your mother were to say, I don't like my job, if she's working, I don't know if she's retired or not, but if she's working, she can't say, I don't like my job, I don't have any other place to go, I'm just going to quit. And children, just so you know, your mom is quitting her employment, so you're all going to have to pick up the slack. You're an adult. And is your mom with you today?
She was this morning, but
All
she
right.
couldn't come.
So your mom was here with you this morning and she's going to work. So here's the thing. You can't just, you're an adult, even though technically you're 20, people still see you as young. 17-year-olds, 18-year-olds, 19-year-olds, people still see them as young, but technically you're an adult. So you got to put away the childish things. You can't just quit a job and say, I'm going to find something else. And for you to be working at Toyota, I'm sure Toyota was paying you well, but you haven't even graduated high school and you got a good job. And it's Toyota. Maybe you don't like the hours. My mom, she used to work on rotating shifts, and you know what her shifts were? And I'm probably going to get this wrong, but I think it was 7 days straight. And she had to do rotating shifts. So she had a morning shift. You do that for 7 days. Then I think they give you like 3 days off. And then you have the middle shift, which is the 3 to 11 shift. You do that for 7 days. Then they give you 3 days off. Then you have the graveyard shifts. It was either 7 days each shift or 14 days each shift. And you know what? She didn't quit that job. You know why she didn't quit that job? Because people were dependent on her paycheck. Her children were dependent on her paycheck. So you need to stop and start growing up and stop thinking that you can just quit a job and a new job is just going to pop up. You understand? Don't quit a job or give them your notice until you know you have another job. And so you're a cook. I'm sure. Where are you a cook at?
I wasn't cook at it.
All right. So you were a cook. So where are you working now?
Currently.
See, you've quit 2 jobs already. And I'm sure Toyota had good benefits. And you know what? The other people who are working that rotating shift, you're behind now. And this is what I mean about your being behind. You're going to look up and you're going to be that person going from job to job. And then the people who are at Toyota with you, they're going to be ready for their retirement. And they're going to say, you know what? I already put in my 20 years. Whereas you may end right back up at Toyota and you'll only have a year in and you're looking at doing 19 more. Don't be a leaf blowing around in the wind. You understand? All right. Any children, do you? Okay.
Trust me, if I did.
I didn't want to ask that question, but I was like, please. You got to work on yourself first before you do that. All right. So there's going to be a $1,500 fine. I'm going to probate that. Not for you. I'm probating it for your mom because I know she would help you pay that. So we're going to probate that. I'm going to place you on 2 years deferred adjudication. You're going to get employment. You understand? And I'm going to require that you stick with that job. The only time you can leave the job you have, of course, if there's something dangerous happening, they're violating OSHA standards. The only time you'll be able to leave that job, if they're not violating OSHA standards, is if you already have another job. You understand? We're not going to do that anymore. So it's going to be proof of employment within 30 days. There's to be no employment as a home health care provider or with minors. Oh, and by the way, at Toyota, that shift you were working, I'm sure if you put enough time in, they probably would have given you a different shift. Those shifts are usually for people that they're trying to see if you're going to last. So if I were in your position and I haven't graduated from high school, Toyota seems like it's a good place to be in as far as benefits, 401k. I'm sure they'll do medical, dental, all of that. You understand? There is going to be regular reporting by Zoom. or in person. There'll be regular random UAs, defensive driving course, 180 hours of community service restitution. That will be waived if he completes his GED, or if he graduates from school, or if he enters and successfully completes a trade school. There's going to be field visits 1 time per month for 2 months. Probation, is there anything else he needs? Is there anything else you need from the court to be successful? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand? All right, so we can go off the record. Here's the thing. You're going 100 miles per hour, and guess what could have happened? One, you're not a race car driver, right? You could have easily hit a child who was walking through the crosswalk, because guess what? Children tend to be walking through crosswalks during school. Could have been somebody from high school. Could have been one of the little elementary school children who are just trying to make it to school, and you're speeding at 100 miles per hour. This is not Fast and the Furious. You understand? And you easily could have been killed. You could have wrapped your vehicle around a light pole, or ran into the school. You understand? All right. And then if that would have happened, you know what? They would have been trying, if you would not have survived, they would have been trying to sue your mom. All right. Good luck to you.
Thank you, Your Honor.
Thank you. We're going to go on the record. And Mr. Echatia, could you unmute your, thank you. The court is calling 2024 CR 1497 State versus Gabriel Paul Echatia. Am I pronouncing your last name correctly?
Yes, ma'am.
All right, thank you. Oh my gosh, that's shocking for me. Okay. Could I have parties announce state
Andrew Harris Edelman.
defense?
Jesse Sepulveda for Gabriel Paul Echatia.
And if you could state your name for the record, sir.
Gabriel Paul Echatia.
All right. So your client is appearing by Zoom. Any objection to us having this hearing with your client by Zoom?
No objection, Your Honor.
All right. Your defense counsel has filed a motion to set bond in this court, the 187th District Court. You're on deferred adjudication, so you're entitled to a bond. The only question is what the amount will be. Have you all discussed an agreement with regards to a bond?
I discussed it with Mr. Edelman as well as Jason Garahan, and they are recommending $10,000 bond, Your Honor. I believe the original amount when Mr. Echatia was originally arrested was $5,000.
All right. And the court, due to the fact that your client is on deferred adjudication out of this court, the court is aware of any type of prior substance abuse issues. But there are a few questions I would like to ask you with regards to your status now. If you could raise your right hand for me, please. Yes. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand. And if you'll state your name for the record again, please.
Gabriel Paul Echatia.
All right. How long have you been in custody in the other county?
About a week, ma'am.
All right. Since that time in custody, have you been placed on any type of mental health division of that jail?
No, ma'am, but they have requested and asked me if I would like to, and I denied.
All right. And so you're not on any type of medication?
No, ma'am.
All right. Then what the court will do, the court will follow your agreed bond recommendation of $10,000. I'm going to order sober support meetings as a condition of your bond, and I'm going to require 30 days, and then we are going to set this for a hearing. We can go off the record. State, what is the status of allegations in the motion? I think there is a number 1 with regards to reckless driving, and it's in Bexar County. Would you have that police report?
No, Judge.
All right.
I might be able to look it up if you'll allow me to.
Yes. I just want to make sure that you have what's needed, and then I can give you all a setting.
Thank you, Judge.
And is he only there because of the warrant here?
I believe so. Is that right, Gabriel?
Yes, sir. And yes, ma'am.
Okay.
Judge, if I may, I was just retained a few days ago, but from what his mother has told me and his brother told me, apparently Gabriel was a complainant on a case. He was stabbed 4 times by some other individual, I think a boyfriend of one of his ex-girlfriends.
Mhm.
And I'd like to, I guess, just be given some time to inquire about that because she says he's not the same individual, that he's had some issues afterwards. And I'm not sure if he's seen a psychologist or psychiatrist, but apparently it was a traumatic event for him.
Okay.
Is that right, Gabriel?
Yes, sir. I haven't seen a psychiatrist or a psychologist after the stabbing or anything. They were recommended therapy through the state. The state was providing it, but after a while they started charging, so I couldn't afford it.
So your case is going to be recalled for April 14th. You should be released. If you are released, you need to be here at 9 a.m. Do you understand?
Yes, ma'am, I understand.
All right. Is there anything else, counsel?
No, Your Honor. Thank you.
All right. Thank you.
And be excused.
Yes, you may be excused.
Good week.
All right. And sir, you can let the deputy know that your hearing is complete. Your attorney will probably get in touch with you or get in touch with your family to see about your Tortilla.
Thank you.
You're welcome.
Judge, I cannot be here Wednesday morning. I'm going to Ernie Karam's funeral
Okay.
and I have a case on you.
Oh, just send the email to Norma and I'll take care of it.
Okay.
You're welcome. Are y'all ready to proceed on the motion to revoke?
We are, Your Honor. Yes.
Court is calling 2024 CR 1497 State versus Gabriel Paul Echatia. Echatia. Sorry.
It's okay.
Could I have parties announced for the record?
Jason Garrett, State Yard.
Jesse Sepulveda for Gabriel Echartea.
And are you Gabriel Echatia?
Yes, ma'am.
Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it? Are you the same Gabriel Paul Echatia who was placed on deferred adjudication in 2024 CR 1497 for the offense of evading arrest or detention with a vehicle on June 17, 2024 for a period of 2 years? All right, state.
Yes, Your Honor, violated condition number 1 on or about the 13th day of February 2025, in Bear County, Texas, the defendant Gabriel Paul Echaria
Close enough.
committed the offense of reckless driving and violation condition number 1.
How do you plead to that? True or not true?
Your Honor, will waive the remaining violations.
Any objections?
No objections, Your Honor.
Did you understand by pleading true to violation of condition number 1, the court could find it true, grant the motion, find you guilty, sentence you up to 10 years in prison and up to a $10,000 fine? Knowing that, do you still wish to plead true to violation of condition number 1? Court will find violation of condition number 1 true. Is there a proposed agreement?
There is, Your Honor.
Yes.
The motion to adjudicate and continue the individual on his deferred and have it amended to include local ISF 2 and wait in jail for placement and monthly UA for 6 months and amend for IOP as represented by the TAP. And the state will take into consideration clause number 2025 CC 002773, which is the reckless driving he just pled true to.
All right. Is that the agreement?
It is, Your
Are you
Honor.
asking the court to follow that agreement?
We are, Your Honor.
All right, can you raise your right hand for me? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand. How old are you?
21.
You're 21. You want to go to prison? Do you want to be over in the box with those gentlemen over there? Some people at the jail, people at the prison, they're charged with murder, right?
Yeah.
They're charged with sex offenses. They're charged with robberies. They've been to prison before. This is their 3rd time or whatever. It appears to the court that maybe that's where you want to go because you're not doing what needs to be done. You're here on an evading arrest with a vehicle. You live with your parents. I can't even believe they're still allowing you to drive. You shouldn't even be driving because obviously you're not mature enough to drive. And this reckless driving, what was that about?
Just made a bad judgment.
No. I didn't ask you whether you made a bad judgment or not. We know you did. That's why you're here. What is it about? How were you driving recklessly? Were you going beyond the speed limit? Were you out here like I see these children do, shutting down in the street doing,
roundabouts? What were you doing?
I was going over the speed.
By how much?
I'm not too sure. It didn't say on the report.
You should, I mean, you should know.
According to the report, Your Honor, I think he turned off his lights and he passed a few stop signs. They said he was driving at a high rate of speed, but they didn't say exactly.
So let
how
me
much.
ask you this. Let's think about this logically. You're young. Sometimes young people don't think logically. You turn off your lights. I'm assuming then this was nighttime.
Was.
You turn off your light at nighttime and you're blowing through stop signs. What do you think the purpose of a stop sign is for?
To stop the vehicle.
But why? Why do we have stop signs? Why do we even have red lights?
In case of pedestrians coming through or cross traffic.
And why, when it's nighttime, why do you have to have your lights on?
So another vehicle or a person can see the vehicle.
So if you turn off your lights, what does that mean? Will people be able to see you? All right. And then somebody is walking past that stop sign because they don't see a vehicle. What's going to end up happening?
Collide with the person or vehicle.
And what's going to happen with that person?
They either die or get seriously
Yeah.
injured.
And let me just tell you what would have happened if you would have hit someone. You would have ended up hitting that person, and you know what you would have done? You would have left the scene. They would have ultimately found you, and then you would have been in the box, and you would have been before me crying, asking for tea and sympathy. So what I can tell you is this. The only reason why you're not going to prison right now is because your age, and I guess you're not thinking. So I'm going to try to help you think and make better decisions. So I'm going to deny the motion. I'm going to alter him in conditions. He will be taken into custody today. He's going to local ISF. And since your family won't do it, I'm going to have to do it. You are not allowed to drive. Wherever you need to go, either you're going to have to get an Uber, you're going to have to learn to do the VIA. You're not going to be driving for the rest of your probation. Don't come back to me saying I have to go to school in another county. You're going to have to figure it out. Do you understand? And I will take in consideration 2025 CC 002773, and we'll do a referral to felony drug court. And all of that is to take place in custody. And then you said intensive outpatient treatment?
Yes, sir. Oh, no, actually, inpatient.
Inpatient treatment. Oh, sorry.
Oh, I'm sorry, Judge, you're right.
Yes.
You got the other part.
All right,
Yes,
so
Your Honor.
that'll be inpatient treatment. And I know that you all didn't go on the section about using marijuana. It's illegal in Texas. You're on probation. You're not allowed to use marijuana. If you want to sit around, fry your brains or whatever, you can't do it while you're on probation. Do you understand? And we can go off the record. What are you planning on doing with the rest of your life?
Join the military.
All right, well, the military, they're not just accepting everybody. And counsel, once he completes all of this, if he signs up for the military and I need to see it signed on the dotted line, I will let him go.
Thank you, Judge.
Thank you.
Will we be excused?
Yes. Umberto.
Thank you. And then on Miss Jallo, Your Honor, this has gotten quite complicated because I did go over the guilty plea form with Miss Jallo back in September. She's here for sentencing. I maintain that I very clearly explained what the agreed recommendation would be, but Miss Jallo is saying she didn't fully understand that she would have to follow through with recommended treatment and has a lot of reservations about that. And I think she has expressed that she would like to just address the court herself and express her wishes regarding sentencing. And that was sort of where the conversation was left off because, yeah.
Okay, Ms. Jello, do you mind unmuting your device, ma'am?
Yes.
Okay, so Ms. Jello, your case is 2A58923. You entered a guilty plea on looking at the plea form right now. And it says no criminal law violations. This is the recommendation of the parties. No criminal law violations. Alcohol and drug evaluation. Don't go back to South Center Mall. Obtain a chemical dependency evaluation and complete whatever treatment is recommended. That was entered, and I accepted that guilty plea. So we're on for sentencing, and presumably you've had that substance abuse evaluation. I'm hearing that you have not done that.
No.
Is there a
Yeah,
particular
Your
reason?
Honor, sorry, Your Honor, I didn't mean to cut it. We've continued this set over sentencing a few times for Ms. Jallo to get the evaluation. And she has expressed to me that it's just at this point something she is apparently unwilling to do. And so I'm a little bit, yes, I'm not sure how to proceed.
Thank you. Ms. Jallo, why don't you come on camera? I can't see you.
Yeah.
Ms. Jallo, are you telling me that you're just gonna, you're gonna disregard the court's order?
Well, I don't want to do it. I thought my thought on the deferred sentence is that if I didn't do it, I just didn't do it, and it stayed on my record, I didn't know that I have consequences.
Now, Ms. Jallo, I went over the plea form with you. I know I am thorough in going over the plea form. So I'm certain I don't even need to listen to the audio because it was me who went through the plea form with you, not a pro tem. I'm looking at some of the other cases. So you now have, sorry, the system is moving a little slowly.
Just for some background, Your Honor, we were initially trying to negotiate with the Burien matter, and we were going to dismiss one of the two cases if she got into drug treatment in another one. So I'm pretty sure she was aware that that was on the table.
And you also now have a pending assault in the fourth degree domestic violence, assault in the fourth degree charge where it looks like there's some kind of ordered effect out of Kent. And the Kent, am I reading that correctly? You look at me like you're surprised. The Kent court had ordered you not to possess or consume any alcohol or non-prescribed drugs for some reason. I haven't seen that report. I don't know what they're alleging in that case, but you also have an 82423 PC controlled substance violation. So my question is there a particular reason that you have not gotten the substance abuse evaluation? Because that's what the court ordered.
I guess I'll go do it, but I'm just not getting complete treatment. I just know I'm not. I mean, I didn't know that I had consequences if I didn't do it. I thought that it just stayed on my record.
The consequences is that you can get up to 364 days in jail for this. This is a criminal offense, and the parties asked to send sentencing over so that the court can get a copy of a substance abuse evaluation so the court can determine what the appropriate sentence is. The court's not bound by any recommendations that the parties are making. The court doesn't have to follow through with any recommendations. And I thought it was perfectly reasonable, all things considered, for you to go get a substance abuse evaluation as the parties had recommended. So if the city is recommending a 24-month deferred sentence, that doesn't mean I have to follow that. In fact, you failed to appear in this case. You have bail posted. You're now telling me that you don't want to go get an evaluation. What is the motivation?
I mean, obviously, I accidentally forgot court. As soon as I found out that I missed court, I went down there and I paid for the bail. If I would have known I had court, I have other things going on in my life, So I mean, it wasn't like I ran. I didn't want to go to court. Do you think I wanted to go pay $500 to get bailed out on this charge? People make mistakes in life. Sorry, I'm not perfect.
Well, I think that's what the parties were telling me by saying, yes, people make mistakes in life, so give someone a chance. So go get a substance abuse evaluation, follow through with a treatment recommendation, and have an opportunity to get your case dismissed. You don't have a clean criminal history. You have criminal conviction. So the recommendation for a deferred sentence by both of the parties is rare for someone with a criminal history. So there's obviously something between the parties that they've discussed about you that warranted that recommendation. So I haven't yet followed that recommendation. I need reason to follow that recommendation. It would be perhaps you're going to do something to resolve any issues that these lawyers know about that I don't know about, and have the benefit of the dismissal. I absolutely agree with you.
The fourth degree assault should be brought up. I'm
sorry,
that you don't know the circumstances behind that.
Miss Jallo, you've been charged with a crime. My job is to look at your criminal history. You have been charged with a crime. City has found probable cause that you've charged with a crime. It's still pending, but the bottom line is you've now been
But
accused of
watch,
a
it's not gonna
substantive
be,
law
I'm not
violation.
gonna, I'm not gonna be
Violation of your
charged with
conditions
it.
of release. I'm sorry?
It didn't happen, so it's not gonna, that shouldn't even be brought up.
Miss Jallo, I
Because I'm not
appreciate
guilty
that
of
you're
it.
trying to tell, I appreciate that you're trying to think that you know how I should be doing my job, but that's not how it works. The bottom line is, and if you're gonna go off camera, you have to come on camera. Otherwise, I'm not gonna allow you to
Okay,
peer
what do you
via
want me to
Zoom.
do? Okay, I'll go get the drug and alcohol evaluation. I'm done with this. I'm done.
Person from now on. And I'm setting sentencing over, and you have to get a substance abuse evaluation between now and that sentencing hearing where you have to appear in person. Okay? I'm not going to allow you to be able to control your court hearing by just removing yourself from the screen or interrupting me. You must appear in court in person in 30 days after having that substance abuse evaluation. Do not miss your court dates in Kent. Because I don't want you to have a warrant. And then we're going to see, based on that evaluation, what the appropriate sentence should be. Hopefully still get that deferred so you can get that case dismissed, but then it'll at least have a professional tell me if treatment is appropriate for you. I mean, we don't want to be left guessing. I want to hear what a professional says. So in the course between the time that you pled guilty and today, did you have a chance to speak to court services about where you can get this evaluation done?
I know where I can get it.
Okay. You know where to get it. And then here's the thing. When you come here for sentencing, you have to have the results of that evaluation in writing. Normally that does take time. So you need to get this done as quickly as possible so that they can have their part done for you to bring in the evaluation results here to court. They may ask you to sign a release so that they can send it to us directly. That's between you and the evaluator. But when you come back to court next time, you have to have that evaluation done. Okay? Your next
Are we
court
done
date.
yet? Are we done?
We're not done. We're not
Okay.
done. Hello. Your next court date is March 13th at 10:30. Is that a Wednesday, Nessa?
What did you set up?
This is exactly why you are not going to appear in Zoom again, Miss Jallo. You are going to be here. Is that a Wednesday, Nessa?
Yes, Your Honor, that's a one.
Okay. March 13th at 10:30, you will appear in person at the Tacoma Justice Center for
Okay, I'll see
sentencing
you then.
with your substance abuse. Don't you dare hang up, Miss Jallo, or I will order a warrant for your arrest.
Well, I mean, what do you want me to do? You told me my next court date's March 13th.
What I'd
I'll
like
be
you to
there.
do, what I'd like you to do is act like you're actually in court. This is the reason why you're not allowed to appear remotely anymore. We're going to email you notice of your next court date. If you do not get an email from us by Tuesday, call the court so that we can follow through to make sure that you receive this document. Do you want to speak to your attorneys before you hang up?
No.
Okay, come back March 13th here at 10:30 with the results of your evaluation so we can go forward with sentencing. You now are free to leave. Thank you.
And Judge, while the court is doing that, I did attempt to advise my client of those charges and we weren't able to get through that. So I would ask the court to advise him of those additional charges.
I'm gonna need to do that, obviously, then, okay, so do you want to take a position with respect to the motion to amend?
Your Honor, I will let the court know that I was having a bit of trouble communicating with my client as we were talking earlier today. So I have some concerns.
Okay, why don't we have you raise those concerns for me then now, because I do want to be able to address the motion to amend.
Well, as I just expressed to the court, I was attempting to advise him of those charges that the city attorney would like to add, and I was not able to get through that conversation with him. I spoke to Mr. Reynolds. I do have some concerns about my ability to communicate with him and his ability to assist in his defense because we are having trouble communicating. I don't know if that's something that's temporary for today. Obviously, I haven't filed a competency motion because I kind of wanted to see how this hearing went. So I guess at the very least, I might ask for some additional time to talk with him about those added charges.
Okay, why don't you do that? I'm inclined to, because of the rules of procedure do allow for a motion to amend to be filed anytime prior to the trial date. Obviously, I would have to advise and take pleas on those additional charges, and that might impact whether we go forward with a jury trial on the existing date or not, because speedy trial could start anew on those two new charges, but we could have some discussion about that as well. So do you want to take a break right now?
I don't think that me speaking with him today is going to be helpful.
All right, so Mr. Mustafa, you've heard Ms. Talene talking about your case, that she's having some difficulty talking to you about your case. Do you want to respond to that?
Yes, that is a biased opinion. She asked me to go out to the room, which we did. Then she asked me to wait because she was texting someone else, whomever, I don't know, it's not my business. While I was waiting for her texting that person, I was carried away. I was looking at the wall, at the ceiling. I don't know, just keeping myself busy, not to get involved with her doing, so to say. After she was done with texting, she looked at me and she's like in elevated voice, she started talking to me. I explained that she doesn't have to raise her voice at me. And she said that I'm not paying attention. I'm looking at the wall. I'm looking at the ceiling. And I explained that while I was doing so, she let me know that she is busy texting or doing whatever business which is not affiliated to my case specifically. And this is the conversation she's bringing out from the room, saying that we couldn't have a conversation and she didn't have a chance to explain about additional charges which were added to my case. It doesn't make sense. Yes, you didn't have a chance to explain because you were busy first texting another client, as you mentioned it, and then you were busy raising your voice at me for no reason. I didn't even understand for what. I mean, what did I do wrong to you? Okay. Then she just walked away from the room and that's all. It was done, basically. She came and she sat here. And now you are having the conversation you are having. That is the case, basically.
All right, so a bit of a conflict today.
Conflict? I didn't even have a chance to express myself verbally in one way or another. As I mentioned previously, she was busy doing her thing. I mean, I cannot be like forcing myself upon someone. If she's busy texting another client while she's in the room with me, and the concern should be like concentrated within my context.
Well, let's take a moment then. There doesn't seem to be anything that prohibits you from having a brief 5 minute conversation with her right now.
She's right that this conversation wouldn't go far.
Why not?
Because it was such a I mean, she walked away from the room like something happened.
Why can't you have a conversation with her now?
She didn't represent me.
Ms. Talene, are you willing to represent the defendant?
Yeah.
All right, so Mr. Mustafa?
You are being dishonest then?
I am not being dishonest. I did not say that.
But you created that impression when you walked out from the room without saying anything, that you're not willing to represent me.
Are you willing to have a conversation with her, Mr. Mustafa, about your case right now?
I don't think this is going to go any further. I mean, after this, what she said, it wouldn't register within my conscious mind. I wouldn't be able to fake any type of conversation.
You're not going to have a conversation with her?
I'm sorry?
You're not going to have a conversation with her when she's willing to have a conversation with you about your case?
But we had a chance though, and it didn't go far.
It is not the court's job to mediate conflicts that you might have with your
I
lawyer.
don't even comprehend the reason of the conflict.
Doesn't seem like there should be a conflict.
With me.
You may not have liked the fact that she wasn't talking to you directly in that moment, but she's providing she's providing you the opportunity to have a conversation with her now about your case. And I don't see a good reason why you should not have that conversation. If you do not want to be represented by a lawyer, you can indicate that, but this is your lawyer. This is the lawyer that I've appointed in your case. If you want a lawyer to represent you, you're going to work with Ms. Talene.
But in this case, our relationship is forced by a court itself.
I'm not forcing a relationship. I'm giving you the opportunity to have counsel. And the court's going to pay for your counsel. That's right. But I'm not forcing that. If you want to have a lawyer represent you, it's Ms. Talene as your lawyer.
Okay, which is my other option?
To represent, you can represent yourself. You can represent yourself in the case if you choose to.
I will express myself verbally and I will say everything what I know, which is related to the case specifically. Ever since you've assigned a lawyer or, the defense to me, we haven't met. We haven't had any conversation over the phone, over the text message, email, any other type of conversation.
Okay.
So, this is basically second time I had a chance to see her.
Right.
And which didn't go far. So
But you're prohibiting it from going forward right now.
She's incompetent about the case. She doesn't know what is going on. We haven't had personal conversations ever. The last one a few minutes ago failed. So, I would have a good chance just to explain myself in the best way possible, that's all. It would be the best choice since she doesn't know and I do. It related to me specifically.
Okay. All right, I've heard from the defendant. Ms. Talene, if you're suggesting that the defendant's position here constitutes an inability to assist in his own defense that would constitute a competency challenge, I don't have that in front of me. I have someone who perhaps doesn't want to interact with you in the way that you want to interact with them, but I don't view that as a competency issue from my perspective. I don't think it's been raised such that I could rule on it.
Well, and as I said, this sort of came up this afternoon, so this wasn't something I had been planning to be discussing.
Right, okay.
Yeah.
But we do have a problem because it appears to me that Mr. Mustafan is not willing to have a conversation with you about his case. Is that right, Mr. Mustafan? You do not want to have a conversation with Ms. Talene at this point?
Well, going back to my previous experience, which we had just had a few minutes ago, I'm recalling unpleasant experience, which is incompetent from her behalf. She's not as, she doesn't behave as one could have expected, specifically within the judicial field. And yes, I'm willing to say things on my own behalf. Yes, I'm expressing myself verbally for my own case.
You're expressing yourself right now. The question that I have.
But the hearing, though, did it start yet, or we are still like?
We've called you.
It's at 2 and we are at least 40 minutes late. Over here, it says 2.
That's right.
Jury readiness conference.
That's right.
I don't know. I don't know how it works. In my opinion, if it says 2, it means 2 exactly. Over here, we are already.
Well, you're not correct in that. It's 2 o'clock for you.
It's double check if we are in a conference or this is a pre-conference. What is this?
Let me explain that.
Thank you.
Right. You are scheduled to be here at 2 o'clock.
Okay.
All right. The court does its best to see cases in a timely manner. It doesn't mean that when someone's scheduled at 2, right at 2, the hearing's going to begin. Because at 2 o'clock, There may be conversations that the prosecutor wants to have with the defendant and the defense lawyer. The court may be engaged in another case at that time. So the case has begun. When I called your case forward, that's when this hearing began.
So about a little over 10 minutes ago?
That's perhaps correct.
Okay.
So the case that we've begun the discussion about this jury readiness conference. The purpose of a jury readiness conference is determine whether the prosecution is ready to proceed with their case and whether the defendant is ready to proceed with their case for the jury trial that is scheduled on another date. And as part of that jury readiness conference, the prosecutor's responsibility is to, if they have legal issues that they want the court to address, they raise those legal issues with me. If the defense has legal issues that they want me to address, the defense can raise those legal issues with me. It's also the last opportunity for people, if they're going to have a plea bargain, a plea agreement that they reach, that they present that to the court. So all of that is part of this jury readiness conference. And so when Ms. Talene is meeting with you, and perhaps she's having conversations with the prosecutor, she's trying to get a handle on what's going to happen next, what your interests are, what the prosecutor's interests are, what legal issues are there. And so that's what the purpose of this is.
In order to resolve everything what you have just said above, we should be meeting more often and just because on the first hour meeting, I've explained that I do not use phone, I do not use texting, I do not use email, I do not use any other type of communication. The best for me is to come over to the courthouse itself for a meeting.
And you're here today.
Yes.
And I'm offering you the opportunity to have the meeting.
Well.
But you can still have that meeting. You could still have it. We're running out of time because it's at some point Ms. Talene has another court appearance, but you could still have a 5 or 10 minute conversation with her right now. But it sounds like you're refusing to do that.
Nothing comes into my mind. I don't know what to say.
First rule on the motion to amend. I'm going to grant the motion to amend the add to 2 charges. And then I'm going to advise the defendant of those 2 charges. And then we're going to go from there. So the prosecutor has filed a motion to amend to add counts 2 and 3. 2 will be threatening bodily injury, which is a violation of section 534 of the Boulder Revised Code. And then count 3 would be use of fighting words in violation of section 536 of the Boulder Revised Code.
I would like to be specific. If someone came up with such a charges, I would like to know what did I say to whom? And
hold on a moment.
When?
Hold on so I can step through this one thing at a time. All right. I don't want you to interrupt me while I'm advising you of the charges, and then I'm going to tell you what they are, and then we'll go from there. So I've told you what those 2 charges are. They have both allegedly occurred on August 27th of 2024. Understand those 2 charges. I can read them to you if you'd like.
I wouldn't make such a claim. I am guessing what is happening over here, but no. And it's not related to my competence.
So they've alleged that you violated, the first charge was a trespassing charge. They've added 2 charges. I've granted their motions to amend. And now I'm telling you about those 2 charges. And as I mentioned, the count 2 that they've added.
Who did I threaten to do anything?
They haven't indicated that yet. They've simply indicated that the count 2 is now a charge of threatening bodily injury under section 534 of the Boulder Revised Code. I'm going to read that ordinance to you.
Okay.
The charge of use of fighting words is a violation of section.
To be specific within the context as well, if you came up with such a charges, I want to know the details.
I understand you want to know the details.
Yes, thank you.
That's not my job to tell you the details. All right.
What do you mean it's not?
My job is to tell you the charge. All right. And where it's my job is to tell you where it's alleged that this has occurred.
So you are judging me without knowing the details?
No. I'm telling you the charge. I'm not judging you. I'm not judging you, Mr. Mustafan. I'm telling you what the charge is. It's merely an allegation. It doesn't mean you committed the charge. I'm just telling you what the charge is. Now, at some point, it's an accusation. It's an accusation only. Use of fighting words says that no person shall, with the intent to harass, annoy, or alarm another person, repeatedly insult, taunt, or challenge another person in a manner likely to provoke a disorderly response.
The only people I had a conversation with that night specifically, it was police officers. That's all. I haven't had any other conversation with any other person.
Understood.
And
Are you,
everything what I've said, it was based on emotional state of mind. That is first. Second, I'm responsible for everything what I've said to a police officer ever in my life. And I'm responsible for what I'm doing.
okay.
And
I'm going to remind you, I'm going to
myself.
ask you again to let me finish telling you what the charge is and then asking you how you'd like to proceed with that charge. Okay?
This is not an actual court. This is a jury readiness conference. It means conference. I'm here to communicate about the case or on behalf of the case.
If you are
I'm
not
here
going to listen
express
to me, we're going to
myself.
have a great deal of trouble. All right? I do not want to be in a position where you continue to speak when I'm asking you to listen. I need you to listen so I can
So
tell
now
you.
you're threatening me then?
I'm not threatening anyone. I'm
You
telling you,
said great deal of trouble.
you're going to have a trouble with getting through your
Great
case.
deal of trouble is expandable for you.
Mr. Mustafan,
Let's see how far it's gonna go.
Mr. Mustafan, I do not want to have to do anything other than tell you what your charges are. That's all I'm trying to accomplish. But you're making it very difficult. You're making it
What does
difficult for us to get.
conference mean? Conference mean is communication on behalf of the case, which is related to the context specifically.
No, this is a time for the parties to confer with the court and let the court know whether or not they've reached a resolution and whether or not they're ready to proceed to trial. It is not a time for you to go talk about the details of the case. This is not that time, actually.
It's
No,
related to me. How do you mean?
it's not. I'm telling you what the rules
I have
are.
a right to ask you about the details or of the false accusation.
Not today you do not.
Specifically,
Not today you
which
don't.
is related to my case.
Not today.
Specifically. Not today, when? When I come back on the court day?
Yeah, on the jury trial date, you'll have the
So
opportunity.
then I'm gonna be able to express myself.
Yes, you are.
And talk on behalf of the case.
Yes,
But today, I'm just listening.
that's right. And being advised of what the new charges are. Okay?
What do I know? I know nothing.
So let me go over that charge with you. The charge is use of fighting words. I've described it. It says no person shall, with the intent to harass, annoy, or alarm another, repeatedly insult, taunt, or challenge another in a manner likely to provoke a disorderly response. That's the allegation that the prosecutor has made against you. They say that that's what occurred on this original date in Great Park.
No.
Do you understand the charge?
Even over here, it's not Chautauqua, it's open space mountain parks. It's two separate properties.
Do you understand the
Located in
charge?
City of Boulder, but it's not the same thing.
Do you understand the charge? Do you understand what he's alleged?
It's amazing the way you speak. If you have to be precise, specifically within the judicial field.
I think I'm being pretty precise.
I don't think so.
I read you the charge. Do you understand what the charge means?
So next.
Do you understand what it means? Do you understand what it means?
Okay, I got the point. Next.
No, but my question is, do you understand the charge?
Yes, but I do not plead guilty.
That's fine. That was going to be my next question. How do you plead to that charge, which is count 2 of use of fighting words? How do you plead?
I plead no guilty.
Okay, that's fine. The third charge, and it's the second one that's been added, is a charge of threatening bodily injury. And I'm not saying you're guilty. I'm simply saying this is the charge. It's an allegation. The allegation is that you threatened bodily injury in violation of section 534 of the Boulder Revised Code. You understand that charge of threatening bodily injury?
I plead no guilty.
Do you understand the charge? You're nodding your head. You don't understand it. Would you like me to read what the ordinance says?
Well, I'm assuming that it says I've threatened to kill someone, yes?
Let me tell you what it says. It says no person.
Specifically a police officer?
Let me tell you what the ordinance says.
Okay, that's fine.
No person shall knowingly, by threat or physical action, place another in fear of imminent bodily injury. Do you understand that charge?
I do.
Okay, and how do you plead to that charge?
Not guilty.
All right. We're getting there. All right, so now I've accepted not guilty pleas. So there's 3 not guilty pleas that have been entered on the 3 charges that are pending.
And everything started with me trying to get water from the water fountain. And this is how far it has come. It's amazing. It is amazing. To me personally, yes. From someone who came from another country, yes.
All right.
I'm stating it to your face. I have no respect to a police officer. And everything what I've said, I'm responsible for it. And that conversation, everything what he came up with is from within that conversation.
Okay.
Okay.
So let's get back to where what we were talking about before. We're now in the position of you having pled not guilty to the 3 charges that are pending. Right now, the case is scheduled for a jury trial for November 14th.
Okay. At 8.
That's right.
Okay.
The question that I have is, right now, Ms. Talene is your lawyer. She's the one that will represent you at that trial.
I don't know how far it's gonna go. I'm not sure. Do I have another option?
Do you have another option?
No, I'm asking if I have an other option.
Yes.
Or, I mean, can I get someone else? Because I don't think we will get along. Just the way she treats me. She doesn't have to raise her voice at me for no reason. I haven't done anything wrong. It's the same over here. I mean, first, she makes me wait while she's communicating with whomever. It's not my business. Second, when she's done texting, like suddenly she woke up and started yelling at me for no reason. Yo, I mean, would you please have a respect?
So if I'm understanding you correctly, you're suggesting that you have what the court calls irreparable differences between you and your lawyer, such that she can no longer represent you. Is that what you're saying?
Or I wouldn't want her to represent me because that is my conscious choice.
You do have the right to choose between whether you are represented or not. In our court, you don't get to simply say, I don't like this lawyer, so I want you to appoint another lawyer.
But
it doesn't work that way.
Alone, though. I mean, she wouldn't even give me a chance to say anything. She just walks away from the room as soon as I ask her not to raise her voice at me. That's all I said, basically. Did I ask something like extraordinary? That I dislike when someone yells at me? Is it inappropriate within the judicial system of United States?
You have come to the conclusion that she's mistreated you. I understand that's how you feel.
Listening how she presented herself in our relationship at the very beginning, yes. This is my personal perception.
Right.
Thank you.
I, of course, wasn't part of that. I didn't see the interaction.
You are busy doing your thing. I mean, I don't have much to... I didn't expect you to be there. I'm explaining myself.
What I'm telling you is I can't simply say, oh, that must be the case, that Ms. Talene didn't listen to you and that she yelled at you and that justifies me putting someone else in the position of being your lawyer. You've said that. I can't conclude that.
I'm not defending myself. I'm just expressing my perception.
I understand.
Judge Khan, I'm just letting you know that the district court has asked me if it is at all possible to go upstairs because there's apparently several very lengthy sentencings.
And are you scheduled to be there at 3?
Yes.
See, her timing is precise. 3 is 3. My timing says 2, but it's gonna start at 2:30. It's not precise.
I mean, if I need to stay down here, that's what it is, what it is.
I think we need to reset the case.
Her time more than you care about my time.
We're going to reset this hearing.
Oh, okay. Got the point.
And then I'm going to look on calendars. I'll start with Ms. Talene and Mr. Reynolds. Are either of you available next Friday at 2:30?
Yes, Your Honor.
Give me one moment, please. Yes.
Okay, so we'll reset this for next Friday at 2:30.
Which is the date?
Friday, the 18th of October. And we're going to give you a written setting notice. You'll have something in writing from our clerk. We'll give you, Ms. Talene, an opportunity to file any motions that you think with respect to whether or not the court should allow your withdrawal or require your withdrawal. And Mr. Reynolds can respond to that. So if you can file that early next week, and we'll give Mr. Reynolds a couple of days to respond, just so I have something in writing to address the legal issues that are before us.
Yeah, and I think I could probably get something filed by Tuesday. Monday, I'm dealing with some bad stuff.
Let's just make Tuesday at 4 p.m. the deadline for you, and then we'll give Mr. Reynolds Thursday at 4 p.m. to be your response, if any. Mr. Reynolds to that. And then I can address that issue next Friday. I need some time to think about this. There's obviously a disconnect between you and Ms. Talene, and
No, there is a disconnect between me and the judicial system, the whole thing.
that may be true as well. I get you.
Thank you.
But we have to figure out a way to get you through your trial and have you fairly represented. And I don't know whether that means having you proceed on your own, or whether it means.
To me, I have to be honest.
And Judge, I am
Just
sorry,
going back
can
to
I-
everything what I've been through here, and just to this specific case that I was trying to get water from the water fountain, which is outside, and how far this has come. That is mind blowing, man. It's amazing to me. It means that you do not make me a better person. That's all I got.
Okay.
And there is a price. A hefty one. Someone would have to pay. As you make me pay, I will make you pay. You don't even look at me because
I'm listening. I'm listening. I'm not afraid. I'm just writing.
And Judge, since I have the date, would it be
see.
possible for me to run upstairs? Since I have the next
Yes,
date
you can.
and my
you can leave.
deadlines.
Yeah, at this point, we're just resetting it for the hearing. We've got the dates.
Okay, thank you.
Are we done? This is it?
I want you to hold on just a moment. Are you gonna print out?
I printed it, give it to him, yes.
And he's already got a signature on it?
A quick signature right there for me, just indicating you know that you're gonna be here.
I will be here.
Okay. All right, Mr. Mustafa, you're free to go. We'll see you next week.